Next, from 2008, our interview with Justice Rita Garman, who is expected to be named the new Chief Justice of the Illinois Supreme Court in October. In this interview, Justice Garman talks to us about the functioning of the court, how the cases are selected, and her approach to her job as a Justice of the Supreme Court. This runs about 25 minutes.
Justice Rita Garman, thank you for joining us on the Illinois Channel and our series, How Illinois State Government Works.
I'm very pleased to be with you today.
We are fortunate today to be sitting here with you in the chamber of the Illinois Supreme Court building in Springfield, and to be joined live in the chamber by the students, 7th graders from St. Linus from Oak Lawn. And it's very appropriate, since this whole series is to educate citizens across the state on how the government works, and in this case, how the Illinois Supreme Court works. So let's start off with just some of the basic questions. You are a justice on the Illinois Supreme Court. How many justices are on the Illinois Supreme Court?
There are 7 justices of the Supreme Court of Illinois.
And how does one get to be a justice on the Supreme Court?
Justices are elected by the people, and we're elected by district. And there are 5 such districts in Illinois. The districts run in bands, really, across the state of Illinois from top to bottom. The first district is Cook County. It's a singular district, and there are 3 justices that are elected from Cook County to the Illinois Supreme Court. They are elected at large. And then there's 1 justice from each of the other 4 districts. I was elected from the 4th district, which is the district in which Springfield sits. And my district runs from Quincy and Adams County on the west to Vermilion County, and my home in Danville on the east, as far north as Dwight in Livingston County, as far south as Jerseyville, which is 20 miles north of Alton. So it's the band of across central Illinois, and then the 5th district is below us.
And when you are elected to the Supreme Court, for how long of a period of time would you sit as a justice?
Our terms are 10 years. And then once we are elected, when our term is completed, we must run for retention if we want to stay on the court. And the retention ballot is a yes-no ballot. It asks the voters in that particular district or area whether that justice should be retained as a justice of the Supreme Court. If they receive a 60% affirmative vote, then they are automatically retained for another 10-year term.
And if one does not receive a 60% retention vote?
Well, then the office is declared vacant, and then it would go to the next general election to elect another member of the court.
Would the justice continue to sit until that election? Or?
No, the justice would be out of office on the first Monday in December following the election.
If a seat became vacant, let's say through the death of a justice, is there any way to fill that position, or does it remain vacant until the election?
No, the other justices of the court would act to appoint someone, to appoint an attorney to, or a judge, to fill that position until the election.
All right. Now, when you have cases here before the Supreme Court, would you happen to have, as we would see on television, defendants sitting here?
We do not. This is a court of review, so the cases we hear are on argument from the lower courts. They're on points of law. And there's an appellant and an appellee in these cases. They're attorneys, and they make the argument based upon what happened at the lower court, asking either that the decision of the lower court be reversed or that the decision of the lower court be affirmed, which means it would stand.
The way the courtroom is organized, as the camera can see behind us, there's the bench and the justices face the courtroom. Right here behind us is the podium. And what is this used for?
This is the podium which the attorneys come to in order to make their argument. The appellant, or the one bringing the appeal, has the opportunity to argue first to the court, and then the appellee.
And those are terms, of course, that the average person does not use.
That's
appellant
correct.
and appellee.
That's right.
Let's go over, spend a little time on how those terms are used.
Well, the appellant is the party that lost at the lower level of the court system, either at the trial level, and if it's a case that bypasses the appellate court, that would come to here. If it's at the appellate level, they would be the losing party. The prevailing party, or the winner at the lower court, is called the appellee. So they're defending the action of the lower court when they are arguing to the Supreme Court.
So as an example, if there was, let's say, a murder case,
Yes,
and someone was convicted, that does not happen here, that happens at a lower court.
that's right.
And the person who was convicted might say, I'm innocent, and appeal.
That's correct.
That would go from, say, the circuit court, which had heard the initial trial,
Right.
and there might have been a jury trial at that level.
Yes.
Would it come then to the Supreme Court, or is there an intermediate court?
In Illinois, it's a three-level system with the Supreme Court at the top and an intermediate court of appeal, the appellate court, a singular appellate court, which sits in the 5 districts I mentioned earlier. And then at the bottom of the pyramid would be the circuit courts that exist in every one of the 102 counties in Illinois.
So if there was a murder case and the person was convicted, and the person who was convicted said, no, I'm innocent, they could appeal, and it would be heard at the appellate court.
That's correct.
Does the defendant then, the convicted person, get to sit at that, or is that a review of the merits of the lower case?
It is not a retrial, either at the appellate court or before the Supreme Court. The arguments in the appellate court, like the arguments in the Supreme Court, are done on the law by the lawyers from the record that has been developed at the trial court level.
Let's spend just a little bit of time on some really basic things. Okay. When we say it's based on the law,
yes.
What is the law?
Well, the law is in a couple of forms. There's statutory law, and statutory laws are laws that are passed by our General Assembly and signed into law by the governor. And there are many such laws. The Vehicle Code provides for speeding violations and improper lane usage, all that's driving under the influence of alcohol. All those kinds of cases are statutory law. Then there is a whole body of law which is called the common law. And the common law isn't written down in statute books. It's law that has developed by court decision, by decisions of the Supreme Court that have set precedent or set the rules for the lower courts and for the people of the state of Illinois.
So if the Illinois Supreme Court had ruled on a decision in a case, let's say in 1955, if that decision from 1955 applied to a case that was then coming back, maybe it was the same type of case,
right.
The attorney arguing here before the Supreme Court might say, as this court found in Smith versus Jones in 1955, that would be an example of what you were referring to.
That would be a clear example. That's called the doctrine of stare decisis, which means that once decided, it stands.
And why is that the case? Why do we operate as a society that way?
Because our forefathers determined that it was important that people have a settled body of law by which to conduct their affairs, so that business people or citizens know in their interactions with each other or with governmental bodies or any other groups, they know the rules, you know what's expected of them and what's necessary.
Let me make an example for our students here. If one was we're playing a game like Monopoly, you would begin by learning the rules of the game before you played. The law, in essence, are the rules of our society.
That's right. They're the rules of society.
And so by having a tradition of laws, it means that there is a consistency in the rules so that someone doesn't just change the rules willy-nilly.
That's right. That's right. So that the rules apply to everyone. They apply across the board, and it gives us stability in our system of government.
Now, going back just briefly over those layers, we had the circuit court, and in our example, the person who was convicted went then to the appellate court.
That's correct.
Let's say the appellate court found some problem with the trial in the circuit court, and they said, we think that this person needs to be retried. That would go against the prosecutor who had the defendant found guilty at the lower court.
Right.
How would that case then move? Would it come to the Supreme Court, or would it go back for a retrial?
If there was in a criminal case, when there was a decision that it should go back to the trial court, in most all cases it would just return to the trial court. It would not come to the Supreme Court unless there was some point of law that the state wanted to raise that would come, they would ask the Supreme Court to take it. The Supreme Court doesn't take every case. Oftentimes we hear people talk about losing a case and they say, I'm going to take it all the way to the Supreme Court. In reality, that doesn't happen. It can't happen. People have a right to appeal from an adverse decision in the courts, in the trial courts, and they can go to the appellate court to get their case reviewed. But once they're reviewed by the appellate court, they don't have a similar automatic appeal to the Supreme Court. We pick and choose the cases we take in large part.
And how are the cases that come before the court selected?
Well, there are a couple of kinds of cases that we must take. For example, we have to take all cases in which the death penalty was imposed in Illinois. Those cases bypass the appellate court and come to the Supreme Court for initial and final determination. And we would hear all post-conviction matters on death penalty cases. Other than that, matters involving the redistricting of the state of Illinois every 10 years by census. If the legislature can't agree on the map, then that ultimately comes to the Supreme Court for a determination. When the statute has been found unconstitutional by either a trial court or an appellate court, that comes to the Supreme Court for ultimate decision. But the largest group of cases that we select are taken on petition for leave to appeal, where the losing party at the appellate court will ask us in a written document to take a particular case, and they must show us reasons why we would take and should take the case. The Supreme Court's duty is to maintain a comprehensive and consistent body of law for the state of Illinois and to be the ultimate determiner of the constitutionality of statutes passed in Illinois. But the Supreme Court doesn't act as a super court to substitute its judgment for what happened at the lower court level.
We're here today. It's May. When actually are you? There's obviously no court case going on now. When does the court meet?
We sit in terms. We sit 5 terms per year. We sit in January and March, in May, September, and November. And we have just today concluded our May term of court.
And then when you're not in term and hearing cases here, what do you do as a Supreme Court justice?
Well, many people think we're on vacation, and that's not the case at all. We are in our district offices, so each of us have our office in our hometown. The 3 justices in Chicago sit in the State of Illinois building in Chicago, 160 North LaSalle. But each of us have our offices in our own district. My office is in Danville. So when I'm not here in Springfield with the other justices of the court, hearing oral arguments and discussing opinions of the court, doing attorney discipline matters and administrative matters, I'm in my chambers in Danville, and we're reviewing those petitions for leave to appeal that I told you are filed. We are reading and researching and on cases that have been argued, that have been assigned to me to write as the author for the Illinois Supreme Court, and we are reading briefs and cases that the court has decided to take. We're reading and evaluating those cases, plus ruling on motions that come to the Supreme Court while the court's not in term.
Now, a Supreme Court justice would have, of course, gone through law school, been a lawyer, and reached a high point in their career by sitting on this court.
Yes.
But how do you, since your education in the law, how do you know what the law is? When an attorney here sits, as we said before, might bring up a reference to a case in 1955, you certainly wouldn't be able to remember any particular case that they brought up that was 40 or 50 years old. How do you stay current, not only on those, well, let's take it one at a time. How do you stay current on those past issues so you would know what that attorney was talking about?
Well, there's, of course, a lot of reading and research that, that takes place. And when they bring these cases, they prepare briefs, which are written documents that tell the court what their points are, what their issues are, and then they have a written argument as to what law should apply or does apply, or what law they want to apply to this particular case. So we have the advantage of having that brief, so we can research the cases that that they have cited to us.
And is that brief, does that come to you before you hear the argument?
It does. So we have the briefs, and in between terms, we'll begin, when I go back to my chambers in Danville, I'll begin to be reading the briefs that will come to the court for September.
We have the room arranged a little bit differently. We would have the different tables where the
Yes.
attorneys would sit. How long do you allow? You have one side and then the opposing
that's
side. How
right.
long would each side have to make their point?
In every kind of case except death penalty cases, they get 20 minutes per side, and the appellant, or the one bringing the appeal, gets 10 minutes for reply or rebuttal. So they get a total of 50 minutes in all cases, other than death penalty. In death penalty, it's 30, 30, and 10, so it's 70 minutes.
Now, you would hear as a court, it might be on a particular day, 3 cases, maybe even 5 cases.
Could be.
You don't rule the day that you hear those cases. You rule. What happens after the case is argued? And if you might, I believe behind this room where the
Yes.
public doesn't get to go,
That's right.
is a chamber where
It's
the
a
judges meet?
conference room. It is a conference room. When we come to hear oral arguments on a case, we have received the briefs of the parties. So we've received the brief of the losing party that wants the court to take some action with regard to what happened at the lower court. We get the brief of the appellee, or the side that's supporting what happened at the lower court, and then a reply brief sometimes from the party bringing the appeal. So we have reviewed those before we come to hear oral argument. Once we hear oral argument, we adjourn to our conference room, and one of the things that the Chief Justice does is to convene the meeting at the conference, and we vote. We take an impression vote as far as what we believe should happen in this particular case as a result of what we've read in the briefs and what we've heard in the argument. And of course, while they're arguing, we have an opportunity to ask questions of the attorneys about their issues or about their cases or their theories and that sort of thing. The Chief Justice assigns us our cases to write, and we get those cases whether we thought in the impression vote that it ought to be affirmed and everybody thought it ought to be reversed, or whether, regardless of the vote. We get those cases assigned to us. The cases are assigned by seniority. So when we go back to our chambers, we receive then from the clerk of the court the record from the lower court, which is the actual trial proceedings and the transcript of proceedings, and any exhibits are then taken to our office. Then we begin the process of in-depth researching not only all of what happened at the lower court, but then a more full investigation of the law. And then it's our responsibility to write an opinion for the court that, based upon all of the research we've done and all of the study of this particular case, how that case should be analyzed and decided by the Illinois Supreme Court.
We have had in the past people say that a person who was guilty got off on a technicality. When you're reviewing these cases, and if it's a death penalty case, but you also do what we call civil cases, which would be lawsuits as compared to, say, criminal cases. But let's take as an example a criminal case. You're not really trying to determine at that point whether the person is guilty or not. Is that correct?
We are not the fact finders, so we don't make the determination of whether someone is guilty, been proved guilty. We may be reviewing the case to determine whether there were sufficient errors at the trial level that would have maybe caused an unfair trial or sufficient error that would require a reversal.
So as we said earlier, you're really trying to determine just if the rules were followed.
That's right, we are. And we don't go into it looking for reasons to overturn what's happened at the lower level, nor do we go into it thinking we're going to sustain what happened at the lower level. We take a look at it depending upon what happened at the lower level and what the rules of the game are.
We have, as we say, a number of seventh graders here from St. Linus School, and perhaps some of them will one day end up being lawyers.
I hope so.
Tell us a little bit, do you enjoy being a justice, and if so, what's fun about being a justice?
Yeah, it is a privilege to be a justice of the court. I could never have dreamed when I was in 7th grade that I would one day be sitting on the Illinois Supreme Court, and it is a distinct honor. It's a very weighty position. There's a lot of responsibility involved. Every decision that this court makes has an effect on the people of the state of Illinois, not only in this case, but it has a ripple effect throughout our society. But it is besides being a privilege, it's a career goal, an aspirational goal to be able to serve the public by bringing to the job the experience that I've had as a lawyer and as a judge in my study, and to try to form this into what the decision of the Supreme Court should be.
There are currently 2 women sitting,
Yes.
yourself and
Yes.
also Justice Ann Burke. It wasn't
Yes.
that long ago that there had not been any women sitting on the
No.
Supreme Court.
Justice Mary Ann McMorrow, who was a Chief Justice of the court for a time and retired last July, was the first woman to serve on the Illinois Supreme Court. And Justice McMorrow was elected in 1992. The court will be 200 years old on 2018. So it wasn't until very late in that process that women came to the court. And I came on, of course, in 2001.
Speaking of, when you mentioned Justice McMurrow was the Chief Justice and the first female Chief Justice of
Yes.
the court. How does one become Chief Justice of the court?
The Chief Justice is elected by the other members of the court. They serve a 3-year term, and we really alternate it by seniority. It is by seniority, but it's alternated between Cook County and downstate. Our current justice is Robert Thomas of the 2nd District. Our next Chief Justice will be Thomas Fitzgerald of Cook County.
And we sometimes think that judges had only been in the law, but actually Chief Justice Thomas has an interesting background.
He does.
What he had done before he became to the court. What
That's right.
was his...
Well, he was the place kicker for the Chicago Bears before he went to finish law school and started practice and became a judge.
Which is actually not unheard of. I think some
No.
other football players in other states have ended up being on the
And he has some
Supreme
wonderful stories to tell us, too.
One last thing, when you again are in out of the term and you're working out of your office, are there other responsibilities you have as a justice of the court for that district?
Well, one duty that I have is when we admit lawyers to the practice, those that have taken the bar examination have received a satisfactory score, have passed the character and fitness exam. When they are admitted, we do that by district. So twice a year, I come to Springfield and we admit new lawyers to the practice. In addition to that, there are a number of speaking engagements that I engage in regularly, and other kinds of ceremonial type of occasions. The court also, when we're not in term, we sometimes have conference calls to discuss matters of concern to the court. So we're never we are really in communication with each other electronically on a regular basis.
Well, Justice Rita Garman, we want to thank you so much for explaining
you.
how the Illinois Supreme Court works, and thank you again for joining us on the Illinois Channel.
Appreciate the opportunity.
Thanks.
Thank you.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.